Start. Para. Having heard both sides and having gone through the record, it appears that the agreement dated 7/7/1995 is a unilateral document executed by the husband of plaintiff in favor of defendant number 1, stating therein that he has sold the suit plot for rupees 25,000. The plaintiff is the owner of the sued plot. The document, however, does not bear signature of the plaintiff and the defendant number 1. The case of the appellant plaintiff will have to be understood in the light of the above. The appellant, who is wife of Kallu Khan, had filed a suit against the respondent defendant for possession of damages. Admittedly, the suit plot is in the name of the appellant. The respondent claiming document Exhibit 78 dated 7/7/1995 as contract have come up with a defense that the suit plot has been sold by the real owner, that is appellant's husband, to respondent number 1 for rupees 25,000. The respondent number 1 then pleaded that he was put in possession of the suit plot and has incurred expenses for construction of house and therefore is entitled for protection under section 53A of the Transfer of Property Act 1882. Para. The plea of respondent was found to be meritorious by the courts below. They, however, have failed to consider the ingredients of a valid contract. To have a valid contract, there has to be proposal and acceptance, and for that the agreement must be signed by both the parties, and if the agreement is not signed, an evidence ought to be laid. The documents approved and signed by the parties in the form of email, letters, telex, telegram and other means of telecommunication to prove the agreement. In the present case, the contract is not signed by the appellant and respondent number 1. The document, which is said to be a contract, has been signed by the appellant's husband. In the circumstances, the respondent number 1 could not have taken a plea of a concluded contract between him and the appellant, neither being signatory to the document. He is further not entitled to seek protection in terms of section 53A of the Act, because the execution of the contract between the parties itself has been not established, and therefore there arises no question of handling over possession of the suit plot in terms of agreement between the parties. Para. Learned counsel for the respondents has relied upon judgment in the case of Shankar Lal and others versus Sharif Bhai, AIR 1961, Bombay 215, to contend that the respondent will be entitled to protection under section 53A of the Act. However, the facts were altogether different. In the said case, the contract was signed on behalf of the vendor. The draft sale deed was prepared. The entire consideration amount was paid. The possession of land was delivered to the purchaser. The sale deed was not registered on account of sudden death of the vendor. The vendor's son instituted a suit for possession, stating therein that they were not parties to the contract. It is in this context the division bench of this court noted that the contract was signed by the then vendor, who was Karta of the family, and thus has signed it on behalf of the family members as well. Such is not the case here. Firstly, the contract itself is not complete. The appellant is not signatory to the contract. Secondly, the appellant's husband and not the appellant has signed the contract. The courts below, and particularly the first appellate court, has validated the contract on the ground that the appellant held the property benami and that the real owner was appellant's husband and therefore was empowered to enter into agreement to sell. This finding, in my view, is not consistent with the provisions of the law for the following reasons. Stop.